Do you think there's any chance that one could use the, I think it's the Human Rights Act about the right to a fair trial and things like that, at the stage of the DWP's reconsideration, if they're taking forever to reconsider? Can you say that's, I mean, I know it's not a court process at that stage, but would it be possible to argue, do you think, that that's
well, I think, I mean,
not in accordance with the human rights?
You can, but it's going to be, I think it's going to be long-winded in any case, because it's a judicial review action. If you're going to use the Human Rights Act, it's not challenging a regulation, it's bringing a new, quite daunting procedure into play, the judicial review in the High Court. There's a judicial review power that the tribunals have, but that only applies once a case has got within the tribunal system. So, your particular example is somebody who's in the mandatory recon period. DWP isn't deciding it quickly enough. It's not yet in the tribunal system, so their judicial review process, which is available and is not as unwieldy as going to the High Court, it's just not available yet. So you'd be looking at acting after there's been an unreasonable delay.
Yes.
You can't launch this judicial review right away. You've got to wait for an unreasonable delay and then complain through judicial review. So it's going to be cumbersome and not immediate. Let me move on then to the last segment of this, really, which is the second problem out of the two major problems caused by mandatory reconsideration, which is that it's the end of the line if the DWP won't admit your late revision request. So DWP is saying adamantly that if a claimant asks for a revision late, and they decide that there are no special reasons, then you cannot go forward to lodge your appeal. And just a reminder that under the old system, you always had this long stop, that if the DWP decision maker didn't admit your appeal, then the case would go forward to a tribunal judge, and they would decide whether you'd got the right special reasons for it to be looked at again. So that's the DWP's very clear view, and the view of CPAG and others is different. Here's something that sets out what the possible ways forward here might be. The phrase is that you can go forward to an appeal when the Secretary of State has considered an application for a revision of a decision. So the key word is considered, I suppose. When has that act of having considered it taken place? So the argument goes that when they look at it and decide not to extend the time, that is looking at it. That does count as considering it. If that is not the case, then effectively they are the ones who are deciding who does and doesn't have good reasons. And I think we're kind of back to Human Rights Act Article 6 territory. There hasn't been an independent assessment, an independent judgment of whether you've got good reasons. So the suggestion here is that you put in your appeal in any event. Now, you won't have a mandatory reconsideration notice, but nevertheless, you put in your appeal. You tell the tribunal that you think that you have got a right of appeal because the DWP has considered your application and rejected it because it's out of time. And then the tribunal system will no doubt reject this, but then you ask for a statement of reasons and go to the upper tribunal on a point of law, which is that you haven't had a right to have your appeal heard. But basically, because the upper tribunal is the one that can decide on whether the law has been applied properly, you are trying to force the case through to get an upper tribunal decision on whether the DWP should or shouldn't have denied your late revision request. So we're expecting that there will be cases going through to the upper tribunal to decide this, and when that happens, it will either be good news for claimants. An upper tribunal may decide in a claimant's favour, and that will allow these kind of cases to go forward, or upper tribunal will reject that argument. And I mean, it could go further up the chain, but eventually that will decide the issue one way or the other. So at the moment, because it's a new piece of law and hasn't been tested, it's open to testing, and until it's tested in this kind of way, it's a runner. To recap what the kind of test cases that are being looked for are, first off, people who have to claim and cannot manage to claim job seekers allowance while waiting for the ESA reconsideration. Also, people who are refused JSA because the DWP tells them that they're too ill to claim. And that is a contradiction in the law, because it's the JSA side has to bow to the ESA side on the fitness for work test. If the ESA says somebody hasn't got limited capability for work, they are fit for work, then that trumps any decision that the JSA side can make about how they're not capable of work. So any case where they do decide that somebody's not capable of work is a case that could be taken up. And thirdly, the ones we just looked at, where DWP refuses a late revision request. If you have any such cases, the email addresses for the people to contact are there. Martin Williams, the advisor at CPAG, and Michael Spencer, the solicitor at CPAG. And the final slide here is a reminder of our helplines here at DRUK.